What is the difference between the TM and the circle R? You can only use the circle R if you have a trademark registration. In the United States, that registration applies to the principal register and the supplemental register. So what do you do if you don't have a registration yet? You should use the TM if you are asserting any trademark rights in your source identifier. For example, if you filed a trademark application, you should use the TM designation to put others on notice that you are claiming trademark rights. I focus heavily in this vlog series about your rights under the United States or federal law. However, trademark is not exclusive to federal law. There are also certain trademark rights available under state law. You may have heard that patents and copyrights are only federal law, and the reason for that is that the United States Constitution in Article 1, Section 8, Clause 8 specifically enumerates the power over patents and copyrights to Congress. This clause does not mention trademarks. Accordingly, states may regulate trademarks. Well then, why does the federal government have power at all, you might ask? Congress can regulate trademarks under the Commerce Clause. This is found in the United States Constitution, Article 1, Section 8, Clause 3. This clause states that Congress shall have power, quote, to regulate commerce with foreign nations and among the several states, end quote. So that's why you need use in commerce to obtain a trademark registration from the USPTO. Within a state's territory, though, they may regulate trademarks as well. I bet you weren't expecting a constitutional law seminar today, but I hope you enjoyed it. To show you an example of state trademark law, I'll use Ohio. You can find Ohio's trademark laws in Ohio Revised Code Chapter 1329. Trademark is defined as any word, name, symbol, device, or combination of any word, name, symbol, or device that is adopted and used by a person to identify and distinguish the goods of that person, including a unique product, from the goods of other persons, and to indicate the source of the goods even if that source is unknown. There's also a list of trademarks that may not be registered and they'll sound familiar and track the Federal Lanham Act. For example, flags, merely descriptive marks, marks that are primarily merely a surname, and marks used by another in Ohio that are not abandoned cannot get a registration in Ohio. Form 534A is the form you will fill out to file a name registration for trade name or fictitious name in Ohio. So for a $39 fee, you can have some rights for your trademark in the state of Ohio. Whether that's a good idea or not is something you should talk to your trademark attorney about. If you have a state-level registration, you could use the TM designation to put others on notice that you are asserting rights in that mark. Another reason some may choose to use TM instead of the circle R is if they are a worldwide entity and they don't have registrations in all jurisdictions they are using the mark in. I'm not sure of FIFA's reasons for using the TM, but this may be the reason you'll see the TM designation for references to the FIFA World Cup. Before we go, there's one more trademark designation to talk about. This one is more rare, but if you see SM, that means service mark. It identifies services instead of goods. This may be used prior to and after registration. Remember that the international classes for services are classes 35 through 45, so you might see the SM designation for hotels, restaurants, legal services, advertising services, etc. Whether you're sporting SM, TM, or the coveted circle R, trademarks are fun.